Before the landmark case, Miranda versus Arizona, the Supreme Court decided the admissibility of confessions on a case-by-case basis. The sole test was whether the confession was voluntary based upon a totality of the circumstances. Voluntariness was determined by the courts based on whether the suspect's will was broken or overborne by the police during interrogation and taking into account all of the facts and circumstances in the case. This approach did not provide much guidance to the lower courts because the Supreme Court had failed to set any definitive guidelines by which the admissibility of confessions could be determined. In general, the court held that confessions could not be obtained by force or coercion. One of the classic cases in this area is the 1936 case Brown versus Mississippi, where a suspect was literally hanged by a rope from the limb of a tree and whipped until he confessed. Obviously, today, in the wake of the Miranda case, we know that this type of confession is clearly inadmissible. As Professors Jeffrey Walker and Craig Hemmons contend in their book, Escobedo versus Illinois is an important case that was handed down by the same court, that being the Warren Court, which ultimately decided Miranda versus Arizona 2 years later. In the Escobedo case, the suspect was arrested for murder. Though he asked repeatedly to see his lawyer, the police denied this request. The Supreme Court ultimately held that Escobedo was denied his right to counsel, and therefore no statement taken during the interrogation could be admitted against him at the trial. Interestingly, the majority opinion as it was written stated that when the investigation is no longer a general inquiry and instead begins to focus on a particular suspect, then the right to counsel applies. This was a huge victory for civil rights advocates and proponents of inmates' rights, and it essentially set the stage for Miranda, and in fact made Miranda necessary because the ruling was somewhat ambiguous and it created confusion in the lower courts. So Escobedo versus Illinois had to be cleared up, and the justices on the Warren Court used the Miranda case to do exactly that. It is noteworthy that Miranda versus Arizona almost did not come to fruition. It was actually decided by a very narrow 5-4 vote. Up until then, probably no other law enforcement case generated more controversy within outside police circles. The Miranda case was also a bit unusual because the court essentially told the police exactly what they should do. Besides finding that a constitutional right had been violated, the court went further and prescribed in no uncertain terms what the police should do. In clear language, the court mandated that a suspect must be warned prior to any questioning, and that he has a right to remain silent and has the right to an attorney. Seldom has the court been as specific in its instructions about what it wanted the police to do. Of course, several cases have been decided by the Supreme Court since the Miranda case. Berkmeyer versus McCarty is worth mentioning because the court essentially decided that an individual is not considered to be in custody during a routine traffic stop. Therefore, roadside questioning does not require an officer to read the driver of a vehicle the Miranda warnings. However, once the officer decides that an arrest will be made, the traffic stop is no longer routine, and Miranda warnings must be given before questioning takes place. In this case, the officer asked the driver if he had been using intoxicants, and the driver admitted to consuming 2 beers and having smoked marijuana. The driver was taken to the county jail and given a blood test. Questioning was resumed, and then McCarty made incriminating statements. Obviously, he was under police custody, and the court held that he should have been Mirandized. This is especially significant because the court essentially decided that Miranda warnings must be given even for misdemeanor cases. It also provided some clarification as to what constituted custody. Today, as a result of this case, if an officer decides to make an arrest and take a driver to the police station for booking, he may only ask preliminary questions such as name and address. If the driver is taken into custody, he must be given his Miranda warnings if he is to be questioned, even for a misdemeanor offense. Otherwise, any statements which are made will not be admissible to the court. So to sum it up, the rule of thumb is that whenever a suspect is interrogated for any type of offense, whether it is a felony, misdemeanor, or even a petty traffic offense, the suspect must be Mirandized. Having said that, though, the court has held in Pennsylvania versus Bruder that roadside questioning of a motorist detained pursuant to a traffic stop does not require Miranda warnings. It is important to note that Miranda warnings are quite different from the right to counsel. Though Miranda versus Arizona is often associated with the suspect's right to counsel, it is based upon the Fifth Amendment. The right to counsel, on the other hand, comes under the Sixth Amendment. Also, the right to counsel applies in many proceedings, including before trial, during trial, and during an appeal of a conviction. The Miranda warnings, on the other hand, apply only during custodial interrogation. Miranda warnings are also given in the absence of a lawyer. However, once the defendant has obtained a lawyer, he or she cannot be questioned in the absence of their attorney unless the right is specifically waived. Also, as mentioned before, Miranda warnings must be given every time there is a custodial interrogation about any offense, with the exception of routine traffic stops. If a suspect is given the Miranda warnings and he or she waives their right to remain silent, a heavy burden rests with the government to demonstrate that the suspect knowingly and intelligently waived this privilege against self-incrimination and the right to retain or appointed counsel. Interestingly enough, as we know from the 2004 case Ybarra versus Alvarado, the police do not always give suspects Miranda warnings. They may often invite an individual to answer questions. If the individual is free to leave, the court has held that it is not necessary to Mirandize an individual. It should be noted that in the Ybarra case, there was a 17-year-old who was questioned by the police without his parents. In this 5-4 decision, the court ruled that the juvenile's statements could be used against him. So this illustrates that police have been permitted to obtain statements without formally having the individual under police custody. In the Ybarra case, the juvenile was not under police custody, which is the main reason as to why he did not have to be Mirandized. Nevertheless, it should be pointed out that the court was deeply divided on this issue. One of the interesting cases that Professor Walker and Hemmons discuss in their book is Brewer versus Williams. In this case, the suspect in a murder case involving a young girl turned himself into the police. His lawyer told him not to talk to the police. However, on the long drive to the police station, the officers gave the suspect the now famous Christian burial speech. The officer indicated that the parents of the missing girl should be entitled to give a Christian burial to the poor child who had been taken away. The defendant took the bait and showed the officers where the body could be found. Interestingly, the court held that the evidence obtained was not admissible because of a violation of the suspect's right to counsel. The defendant had clearly asserted this right, and there was no evidence of an intelligent, voluntary waiver. So even though there was actually no formal interrogation, the court held that an interrogation nevertheless occurred by the police. The police knew the suspect's religious interests and made remarks designed to appeal to those interests in order to induce a confession. Also, Brewer is a right to counsel case, and although it does illustrate the type of police behavior that is considered to be the functional equivalent of an interrogation. Interestingly, the U.S. Supreme Court has also carved out a public safety exception involving Miranda rights. In New York versus Quarles, the court held that when questions are asked by police officers and they're reasonably prompted by concern for public safety, well, then the responses are admissible in court even though the suspect was in police custody and not given Miranda warnings. So there are exceptions to the rules which regulate the questioning of suspects. And believe me, good police detectives are familiar with court decisions regarding custodial interrogation. They know what they can legally do to get a suspect to confess, and often receive formal training which teaches them to be deceptive yet still obtain confessions which are valid and legal. It is always interesting to see what type of ingenuity that officers will come up with in order to obtain confessions. In Illinois versus Perkins, the court decided that an undercover law enforcement officer may even pose as a fellow inmate in order to ask questions which might produce an incriminating response. The reasoning behind this case is that the court held that a coercive atmosphere is simply not present when an incarcerated person speaks freely to someone he believes to be a fellow inmate. As long as the suspect does not believe he is having a conversation with a law enforcement officer who has official power over him, then the conversation is admissible. Clearly, the court has quite a bit to say about the questioning of suspects throughout the years, and this lecture has only touched on the tip of the iceberg. As you read through the material for this week, try to focus on key aspects of the various cases which seem especially relevant to the discussion of questioning by the police, and reflect upon readings and rulings that you feel are pertinent, and also try to point out issues which are worthy of further examination and analysis in this week's discussion forum. Have a wonderful week.